On charges of gross dishonesty, gross misconduct and abuse of power. We take you now live to the proceedings.
As a trainee journalist, that when he applied for a position as a trainee journalist, he completed an application and recorded that he had passed under 10 at the age of 23 with the following subject: English E, Sotho E, Afrikaans E, Bips E, History F. That he was appointed to the above mentioned position on the basis that he has passed standard 10 as indicated in the application form. That the employee continued to make the same claim and representation in his subsequent application for employment at the SABC. That he misprinted the facts relating to his qualifications, in that he did not possess standard 10 as he alleged to have passed in his application form. That he knew the representation he made in the application form was not true, and he continued to make nonetheless. Charge number 2 is a misconduct, in that on or about first day of February 2012, he transferred Miss Motsoeneng, not Miss Motsoeneng, from position of general compliance to the position of monetary aid compliance and operation services. I'm asking for amendment.
That's fine.
The new charge in which the new post in which he created, not the charge, as he offered.
Just stop the look. It's just your argument, so it's not a charge.
It's not a charge. It's a post.
Yeah. Okay, fine.
As he offered a fixed term of contract for duration of 5 years at a salary package of 1.5 million per annum. It is alleged that this position was never advertised internally or externally as required by the SABC recruitment selection policy.
Okay, just stop there. I don't want to interrupt you all the time.
Yes.
But you are now, where in the evidence was this before me that you are now submitting here?
It is a charge sheet.
Is the charge sheet?
Yes.
And the allegations in the charge sheet?
Yes.
Is that what you are saying here?
Yes.
All right.
These are the charges. These are the allegations on the charge sheet.
Okay, so you're dealing with the charges?
Yeah, the charges.
Okay.
I will come to the evaluation of evidence.
Okay, thank you.
Thank you, Chair. It is further alleged that no interviews process were conducted in appointing Ms. Motsoeneng, not Mrs. Motsoeneng, to the latter position. It is further alleged that he appointed Ms. Motsoeneng to the latter position without having complied with the SABC delegation authority framework. The above selection required that the appointment to the newly created position must be approved by the Executive Committee. It was never approved to the latter committee. His action in the above regard contravening the provision of the selection of the recruitment policies constitutes gross misconduct. Abuse of position is count charge number 3. In that it is alleged that during his tenure as the COO, he unfairly dismissed senior staff members in the SABC for differing in opinion with him. It is alleged that he directly initiated the dismissal or termination of employment of the following individual: Bernard Goma, Hosia Gianni, Solotulo, Monvenyani Dipogo, Ms. Mapula Mbalati, Nzwaki Ramaphosa. Employer's case. The employer presented its case through testimonies of 5 witnesses, whom were following. The first witness was Jabulani Mabasa. The witness testified that...
Whoa. At this point in time, you're going to now summarize here what
Yes.
the witnesses in camera have said.
Oh, okay.
I've not made my final ruling on that. So perhaps this is the appropriate time that you tell me what your approach on that is, because you cannot just start arguing here in public what they testified when you asked for it to be in camera. You understand what I'm saying?
Yes. The ruling should
Are you
be...
abandoning the in camera then?
No. The ruling should be
Because
that.
I have to make a ruling on that.
Yes. I'm not abandoning it.
Well, you are starting to motivate in public what they have testified.
No, I haven't started. I will leave it.
Sorry, just a second. Yes, Mr.
Chair,
Jago.
I also didn't want to unduly, inconvenience my colleague because we are at the argument stage. But that's precisely the point. I was just about to interject and find whether or not is he deciding now to lift that veil. Because obviously he is now about to start dealing with the evaluation of evidence that was obtained in camera, and we are now in the full glare of the camera. It doesn't bother me at all because you are the one who asked for it to be in camera. So, Chair, may I suggest, so that we are not unfair on him, let perhaps the Chair give us a ruling on that issue. Because when in the fullness of time, when my turn comes, I was going to bring an application to you on exactly the same point.
Right. Mr. Palani, I understand that you are just referring to your initial argument and that perhaps you want to deal with detail later when you evaluate the evidence. But I'm in a difficult position now because you have applied and I provisionally allowed you to lead your evidence in camera, and that I would like to make my ruling on whether it is lifted or not, depending on what the evidence was. But I think for the purposes of yourselves arguing on those, you must tell me that you want to argue those witnesses in camera still, or do you want that argument now to be cited before you argue?
It should be argued in camera because they've indicated that they are still in place of SABC and the ruling was made. I think it will be appropriate for it to be in camera.
You see, the problem is then I have to hear your argument in camera and then out of camera, and that's inconvenient, you understand?
But
so I think I'm going to make the ruling now that I don't want to catch you off guard now.
Yes.
I think best is, for purposes of convenience of everybody, perhaps you must now request me or address me on whether the evidence that you let in camera, whether that should be finalized in your favor or not. Because that makes it easy for everyone to either argue whatever who said and cross-argue and whatever. Because perhaps it might be that you want to refer me to a witness who argued not in camera, who corroborates someone in camera. You understand what I'm saying? So this is better for me. I think I'm going to make the ruling now that perhaps if you are ready, why I should make a final ruling in your favor of the witnesses who testified in camera or not. Are you ready to do that?
I would submit that I'm not going to. I may leave out the testimony of the witnesses that testified in camera.
But I want to hear you on that. What do you think of that? And what you want me to find as a fact or not, you understand? I have to first make a factual finding on the evidence and then evaluate in terms of what is alleged against Mr. Motsoeneng and whether he's contravened those charges or not. So I want you to address me on all the evidence in front of me, you see.
What I suggest maybe could be is that we may not refer names. Let's say that maybe witness number 1, 2, and 3.
No, sir. I'm not going to do that. It's either in camera or not, and I want now you to address me why I should make a final ruling in your favor or not. Because then it's easy to argue after whether it's in camera or not, you understand?
Yes. Especially the witnesses are there in place of the SABC. They've demanded protection. They didn't want their evidence to be heard in public when they were testifying for strange reasons that for the reasons that they will be prejudiced. So I believe that to now deal with their evidence in the media and in front of the camera will defeat the purpose on which they were testifying.
Correct.
Yes. So
that's why I want now you to address me on whether it should still be ruled in camera finally or not.
It should be ruled in camera finally.
Yes, but you must address me why. Why? You're asking me, I understand you're asking me that, but you should convince me why. Because we've heard the evidence now, and you must now argue why, in terms of the prerequisites of evidence in camera, why that should be a final ruling now. That's what you want, so tell me why. I'm referring to what we've heard.
Yes, I've already told you, Chair, that the issue is if this evidence is to be on the media and in camera, the employees will be prejudiced, and the protection they sought during the application will no longer be there, because now everything that they said now is going to be on the public.
Yes, correct. Initially, you indicated that they would be prejudiced.
Yes.
And I was leaning over to you to assist you that I provisionally allow that.
Yes.
And because of the interest of justice, I wanted to hear them, and I want to now know from you whether those witnesses confirmed what you had addressed to me initially, if it is a fact that they should stay in camera or not. You understand where I'm going? You understand what I'm
Yeah, it is a fact. Their evidence should remain in.
Yes, but where was the evidence that they were going to be prejudiced when they testified? I never heard anything like that, did I? You never led them on that. Why should I rule that it still stays in camera? You understand? Perhaps I should adjourn a bit, that you get proper instructions. And after you've addressed me, because remember, you applied that I should hear the evidence in camera on the basis that they were going to be prejudiced.
Yes, Chair.
Correct. And
yes.
I was on the verge of not allowing you that, but in the interest of justice, I did. And I said provisionally my ruling was that it was in camera, and you should convince me during this evidence why there should be a final ruling that it does, with the prerequisites of having evidence in camera, why it should be accepted. You understand that?
Just to indicate the prejudice, I will go to the witness of number.
No. I think I said I'll adjourn first, that you get proper instructions. Sorry, Mr. Majabo. You want to reply quickly?
Indeed, Chair.
Yes?
You know, to be frank, even and obviously if the Chair makes that ruling, I'll abide by it, whether we should adjourn or not. But I'm saying, Chair, with respect, this is bordering on being ridiculous now. The application that you granted in favor of the employer, as brought by my colleague, was simply anchored on the following basis. Firstly, he made all of us believe that the only request he was making was with specific reference to the cameras. You ruled, Chair, that the cameras must be shut off. And I remember the two cameras that were to my left even had to face that window. As we are about to start, and the record will bear me out, he then brought another application to say, no, I want the entire media out. You then said, Chair, now, Mr. Palani, you are bringing a different application on a different basis that supported my earlier ruling. Let us re-adjudicate this matter. The matter stood down, he took instructions, came back and he said, if they testify in the presence of the media, then they would rather not testify, holding us to ransom. You nevertheless proceeded again and granted a ruling in their favor, and the entire media houses were cleared. I even made the point to say, I fail to see on what rational basis can a non-invasive microphone hinder a person from testifying. The central issue here was their ability to testify at the time. They have testified, they have been cross-examined quite thoroughly by myself, they were re-examined by my colleague. There cannot be any prejudice. We are referring to what has happened. There is nothing that warrants any taking of instructions, because it is there. He's giving me his heads of arguments or submissions referring to those specific people. Now, how am I going to argue against those by referring to them as witness A, witness B? It cannot be. The prejudice that he said was, if the cameras are glaring at them, if the microphones are there, it will hinder them in testifying at the time. That prejudice has now been averted in that they testified in the absence of the media. There can therefore not be any rational basis on why. As a matter of fact, Chair, if you had not pointed that out to my colleague, he was obliviously going to go on. He was about to say, he mentioned a witness whose name I'm not going to mention. And he was about to make mention of what they testified. Now, where was that prejudice before you stopped him? It is honestly, and I say this with the greatest of respect to my colleague, it is now bordering on being ridiculous. I'm opposed to any further standing down of this matter. We accommodated all of us. We started late.
Thank you, Mr. Majogo. Any reply on that, Mr. Palani?
My reply will be to go to your earlier suggestion, maybe to take instruction from you.
Yes, but you must understand, I've been very lenient on you.
Yes.
And I understand the situation because on Monday morning only you got instructions. But we should sort, at this point in time, get our acts now together at some sort, you
I
understand?
agree with you.
But I do not want to prejudice you. But you must please understand that I cannot stand down all the time. If you are not ready to argue, then you must say so. But I understood you to be ready, and now I see you are referring to in-camera evidence in the open court. And my ruling is now that you should address me on that first, or not. Or are you abandoning or not? So that might be a bit ambushing on you because I see you didn't understand this properly. But if you want instructions, I'm going to adjourn for 5 minutes, and I'm not going to wait for you again. You must please be on time now. Are you clear on that, sir?
I'm clear.
I will adjourn for 5 minutes and then we start. And then you must argue.
As the chair pleases.
Disciplinary